Welcome back. In this lecture, we will study the second major period of Roman law. This is the formative period, also known as the preclassical period. If the archaic period was marked by the 12 tables, then the formative period was marked by something called the jus honorarium. So remember that the jus civile is the law that applies to Roman citizens. And at this point in Roman legal history, the jus civile is made up of the 12 tables plus additional written law, both imperial law and legislation, that had been promulgated during the archaic and early formative period. Most of the customary law had been displaced by these written laws by the time of the formative period. But the star of the preclassical period was not the written law itself, but was instead the jus honorarium. So, what is the jus honorarium? Well, in a simple sense, it is the jus civile, but as it is interpreted and applied, principally by two actors, the praetor and the jurisconsult. Now, in order to understand what the jus honorarium is and why it is significant, we need to understand a little bit about how legal procedure evolved by the beginning of the preclassical period, as well as the legal actors involved in that procedure. So, the system for administration of justice in the preclassical period involved three primary legal actors. The first two were the praetor and the iudex. The praetor was an elected official whose job it was to apply the law in civil disputes. The praetor would hear the complaint of an aggrieved citizen and consider whether, assuming what the citizen said was true, the law could hypothetically grant some relief to that litigant. Said another way, the praetor had to decide whether a remedy existed for the type of grievance that the litigant was complaining about. In the language of modern civil procedure, we would say that the job of the praetor was to decide if the plaintiff had a cause of action. If the praetor determined that the law afforded a remedy for the complainant, then the praetor would not decide the case himself, but rather, at this point, would refer the case to the iudex. Now, the iudex was a layman whose job it was to act as a finder of fact in legal disputes. He was kind of like a one-man jury. He was responsible for hearing the facts of the case and determining whether the plaintiff had succeeded in proving his case. So, for example, let's say that an aggrieved citizen came before the praetor and alleged that his neighbor had defrauded him out of some goats. The citizen's neighbor had said that he would buy the goats, and he agreed to hand them over to his neighbor, thinking he'd get some money in return, but then the neighbor never paid and, in fact, never intended to pay. The neighbor had committed fraud. Now, the citizen goes to the praetor and complains. The praetor would consult the jus civile. Right? Remember, this is made up of the 12 tables, which would include both the letter of the law and hundreds of years of interpretations. And then the jus civile would also include those other sources of written law that we discussed. The praetor would use all of this written law to determine if a cause of action existed. If that body of law indicated that the plaintiff could get relief if he can prove this actually happened to him, now we'll refer the case to the iudex. And the iudex will investigate the facts to see if, in fact, this fraud had occurred. Now, integral to this whole process were the so-called jurisconsults, also called jurists. These people were legal scholars who served as consultants. Now, keep in mind, the praetor was an elected official, and the iudex was a layman. Neither one of these individuals had any legal training. So the jurisconsults, who did have legal training, they served as advisors. They advised the praetor regarding the interpretation of the jus civile and in determining whether the law provided a remedy to an aggrieved litigant. They advised the iudex regarding findings of fact. They advised litigants in drawing up court documents, and they wrote textbooks for other legal scholars, right? So they were very significant figures during the preclassical period. The jurists had no official legal authority, at least not at this stage in Roman legal history, but their opinions were nevertheless widely regarded as authoritative for several reasons. These were generally members of the upper class, and so they were wealthy individuals who could enjoy the luxury of legal study. They performed high quality work, and they did so out of a sense of civic and scholarly commitment. They were also unpaid. And while they consulted with both legal actors and litigants, they were considered to be impartial, detached, and fair. Importantly, the work of the pre-classical jurists was extremely practical. They concerned themselves with questions of law arising from specific cases. They did not attempt to develop a systematic approach to the law, but instead they analyzed individual cases and they reasoned by analogy to make predictions about how new cases should be resolved based on cases that had been decided in the past. So in general, the jus honorarium, right, this law that's being developed through this process, was casuistic. What does that mean, casuistic? It means case-based. It developed slowly, incrementally, under the press of actual litigation, and it dealt with individual problems. The law was not conceived of in abstract or theoretical terms, at least not yet. All right, now that we've talked about the legal actors during the formative period, let's talk about the body of law that they developed, the jus honorarium. Now, earlier I alluded to the fact that the jus honorarium was the law as it was interpreted and applied by the praetors. But the term jus honorarium is actually a little more specific than that. The jus honorarium is specifically the law that was developed through the so-called formulary system of Roman law. So we need to talk about that for just a moment. A formula in the Roman law was a document that consisted of the praetor's instructions to the iudex regarding a litigant's claim. This was the legal document that recognized the existence of the plaintiff's claim under the Roman law. Remember, we said that the praetor would determine whether a cause of action existed by consulting the jus civile. Whatever the praetor decided was recorded in the formula, which also contained the remedy to which the plaintiff would be entitled if the iudex found that the allegations were supported by the evidence, right? So the plaintiff here has a cause of action for fraud, and if these facts can be proven, then he's entitled to X sum of money, right? That would be the basic framework of the formula. You can think of these formula sort of loosely as being similar to reported cases in our modern American legal system. They were the records showing that a plaintiff had prevailed on the merits. Now, the praetor issued hundreds of these formula every year, and at the end of every year, all of the formula were compiled in a single publication that was called the edict. Litigants, before bringing a claim before the praetor, began to consult the edict to make sure that the law afforded them with a remedy, to determine whether their grievance warranted any relief under the law. So the edict becomes a source of law that is consulted alongside the original sources. Now, I've said before that the jus honorarium is a new source of law, but we need to dig a little bit deeper into that. Because you see, the praetors were not really authorized to make law. They weren't legislators, but they were quasi-executive, quasi-judicial figures. They were supposed to interpret and apply the law. Nevertheless, through the power of interpretation, the written law was again expanded beyond its original letter. And whereas at the outset of the pre-classical period, the number and variety of circumstances under which the law might afford a potential litigant with a remedy was rather small, this changed over time, right? The praetor began to apply narrow rules in a broader and broader fashion so that they would encompass more types of cases. Let me give you a simple example to illustrate the point. So let's say that the Roman law, the jus civile, forbade a neighbor from cutting down his neighbor's tree that was maybe overhanging a common wall. So the tree would stretch into the neighbor's property, and so the neighbor was not allowed to cut down the branches. Now let's say that a citizen comes to court complaining that his neighbor has cut down, not his tree, but his vines, his beautiful grapevines that were growing up and over the common wall. The vine is damaged and dies. Does our citizen have a remedy here? Well, not by the letter of the law, right? No, there's nothing in the law about vines. The law only speaks about trees. If the praetor applied the law literally, our citizen here would be out of luck. But the praetor might apply the law expansively, drawing an analogy between trees and vines, so that the new situation would fit into the parameters of the law. So the law expanded again without the need for legislative reform. This is why the jus honorarium is a new source of law. It contains all of the expansions and adaptations of the original written law. And each year, the formula that the praetor issued when expanding the law, they were published in the new edict. And then over time, when litigants came to court, the praetors didn't really consult the original law anymore. They just consulted the most recent edict. Thus, the expanded law became incorporated into the law itself and ultimately became the baseline for future litigants. Now, because of the edict and its interpretation by the praetors, the pre-classical period of Roman law is marked by increased flexibility and rapid expansion of the law. But this just wasn't the case as a matter of substantive law. That is, it wasn't just the legal rules that were becoming more flexible and expanding beyond their letter. The pre-classical period was also a period that was marked by increased procedural flexibility. In fact, at the very beginning of the pre-classical period, there was no formulary system in place yet. Instead, there was another system of litigation called the legis actiones, or legal actions. So this system was extremely rigid and formulaic, so much so that it's really almost hard for us to wrap our heads around, to conceptualize a system like this, because it's just so foreign to the way that we handle civil disputes today. So what would happen under the old system is that the plaintiff, the complaining party, had to verbally summon the defendant to court in the marketplace. And then once they were in the courtroom, there was a ritual or exchange of words and gestures, like literally waving your hands or a staff at a certain time, saying magic words. And the plaintiff had to get it all just right or risk the case being dismissed. Now, there were there was a limited number of actions under this system. And so only under very few circumstances could an aggrieved litigant get relief. And again, of course, the litigant had to do everything just right to be heard in court. To remedy these deficiencies, the praetors who introduced the formulary system, which, as we've just seen, allowed a litigant to just come in and tell his story to the court, the praetors were the ones who introduced this system. If the praetor thought that there was a cause of action based on his knowledge of the law, then the case could proceed. There was no reason for certain rituals or gestures or magic words. As a result, more claims were heard and successful. All right, this brings us to the end of our discussion of the pre-classical period of Roman law. In the next lecture, we'll take up the last two periods of Roman law in a single lecture. These are the classical period and the post-classical period of Roman law.